SJC-10253, Tynan versus the Attorney General.
Mr. Tynan, good morning.
Good morning, Judge. How are you? Happy New Year to you all. I'm sorry to be back here again, but I need a clearer case to move on. We all know why we're here. We're here to decide today whether or not a preclusion, a motion to dismiss pursuant to the doctrine of claim preclusion lies to thwart an effort pursuant to Article 7 of the Massachusetts Constitution to derail the people's absolute right to control their government without governmental influence involved. It does not. Anything from Justice Cordy's era to Justice Ireland's original contestment, to Mr. Sachs's briefs, to his letters, to any act that in any way is to derail the people's absolute right pursuant to 7 manifests in contestment. Contestment is not allowed, as the people's rights may not be disputed. The people could not at any time transfer to the government co-equal power with it. There is absolutely no place to go. Article 7 was constructed to be used at times like this. Mr. Adams wrote it, and he put it there. The people, in November of 1919, committed reversible error, as did the government when they offered the people alternative methods with which to reform their governments, including assigning for themselves a right of veto over their petitions, which takes place in the legislature, or enacting exclusive provisions protecting this court from the people's reform. This court is a branch of the government. It is subject to the people's reform at all times when they decide, not subject to an inferior process constructed by an inferior convention outside of the Declaration of Rights, which is not interminglable with the frame. These are separate and distinct jurisdictions, and we, the people, me and them and a lot of others, object to it. We represent the people here. The government is an agent. Its purpose is to serve. In Cordy's decision, he stated that claim preclusion, if it could be applied, I'll grant you that for a second, would preclude this action. Well, these actions are not the same. I changed them in specific places. The original action was based upon Article 7. This one is based in a form consistent with Goodrich versus Connecticut, which announces a prenumber theory of 4, 5, and 7 Articles MDR. These three, taken together, make clear that the government was never at any time to be in a place above its people, that it may not at any time interfere with their rights to reform the government, to alter the government, or indeed totally change the government, including the disbanding of this court and the adoption of a federal locus. Now, these words are written by Mr. Adams. They're not written by me. You know, I just study these things. That's what I do. And that's just the way it is. And I'm sorry, but that's just the way it is. You can't get there from here. This article is a thing of beauty. It's incontestable. It may not be disputed. It may not be discussed. The people may not transfer the power. So it's not just a right. It's an obligation to carry this out alone, that your destiny will be decided by you, that no crown, which is consistent with the history of the times in which this constitutional codicil was established. We had just thrown off a tyrannical government by the force of arms. When he's talking about it may not be disputed, he means by the government. Only the government. That is a fact, and you cannot deny that fact. That's there, it says it, and it is there. Mr. Sachs here is a fine man, but he's not really here because Ms. Doyle could not take in his contestment for claim preclusion. Justice Cordy couldn't read it because you cannot discuss it, because you cannot dispute it. It is sacrosanct. As Justice Botsford said in her hearings up on the Hill, nothing is cast in legal concrete. Well, Articles 1 through 7 are legal concrete. And while I'm here, Article 30 is a nullity. It ended any applicable use upon the transferring of the people's jurisdiction to the United States. Anything that the Attorney General did, and they are not a respondent, they are a defendant. These are two different things in this particular article. Two different things. There's not always a time when the government can defend itself, and that is when its own people call it before it. This injunction was brought in a half hour originally to Ireland. Now, when we did that, we did it with a plan. We have no bane with any policy. We are the keeper of the Declaration of Rights. We're not going to go away. When we brought that in, he had an absolute duty under this court's standards, whether it be the reasonable man standard or strict scrutiny, to issue the injunction immediately upon the reading of 7. He either did know or he should have known at that time that this foreclosed any action by any agency of the government, be it the legislature or this court, to intervene with the people's rights to alter or reform their government. In the instant action, which was just a vehicle that we brought it in, it was the same-sex matter, vote not to vote. You cannot prevent the people from voting. You cannot superimpose your policies, your thinking, or the government's thinking upon the people. They impose theirs on you. The Constitution, the Declaration, the first, has been made a mockery of. You've done away with the absolute accountability. You're all now above the law. Well, you're not. In this generation, we come in words. In the generations ahead, will they come with guns? Because that's what they did to the king. Are you kings? Are you queens? Or are you people? This says, we the people. This codicil forecloses any contestment in any form, whether it's a judicial decision, an opposition. It makes no difference. When this paper landed in this court had an absolute fiduciary duty to enforce it, regardless of its own political thinking, regardless of what it says in the Constitution, which, as I've told the court, I will bring before it in expectation thinking this year. It's not what you want or what you think, it's what we expect. And we expect this Constitution of Adams, which is a thing of beauty, to be followed. We don't expect it to be mitigated when you cannot mitigate it. Indisputable, non-transferable, and those are non-voidable. Therefore, the legislature could not suggest, discuss, nor could the people transfer any power that would make the legislature co-equal or give them a veto over the people's rights to reform. That's it. There's nothing tenable as a matter of law, and I'm pretty good at it. Nothing gets anywhere. It was over on that date. Now, we've made our complaints relative to it. I'm here because I'm going where I'm going, but you have a duty under your own standards, and I have them all. I've been reading them for years. So we have a duty as people, as citizens of this Commonwealth, to see to it that this Constitution is followed. Amendment 48 was not creatable. Therefore, Justice Ireland, Mr. Sachs, or the Office of the Attorney General, I apologize, sir, or the Office of the Attorney General, or this court, none of you has the authority with which to contest the words of Mr. Adams. That's it.
Thank you, Mr.
Thank you
Tynan.
very nice. Have a nice day.
Thank you, Mr. Tynan. Mr. Sachs?
Thank you, Your Honor. Peter Sachs, Assistant Attorney General for the defendants. We did not file a brief in this matter, but rather a letter asking that the decision be affirmed on the basis stated by the single justice. So unless the court has questions, I don't intend to say more to the court at this time.
Thank you, Mr. Sachs.
Thank you.